IRS, taxes, and losing US citizenship. What you need to know now. Imagine living in America for years, building a career, paying taxes, raising a family, and finally achieving US citizenship, only to have it stripped away because of a small tax mistake made before naturalizing. It sounds unthinkable, but this isn't a rumor. It's official. Denaturalization is now one of the top 5 civil enforcement priorities of the U.S. Justice Department. In a memo released June 11th, the DOJ confirmed it is actively expanding its denaturalization work, and not just for rare, high-profile criminals. Instead, they're opening the door to target ordinary people, naturalized citizens who made financial errors years ago and never disclosed them during their citizenship process. And yes, that includes tax mistakes, even small ones. Why denaturalization is back in the spotlight. For decades, denaturalization was almost unheard of. Historically, the government reserved it for cases involving Nazi war criminals, spies, and serious fraudsters. Now, the focus is shifting to civil denaturalization, a process with no statute of limitations. This means the government can dig back into your pre-citizenship history, no matter how long ago it happened. The 2 main triggers remain: illegally obtaining citizenship, applying when you weren't eligible, misrepresenting a material fact during your naturalization process. If a tax issue happened before you naturalized and it wasn't disclosed, it can be reclassified as misrepresentation, putting your citizenship at risk. Where the IRS fits in. The DOJ's new priorities specifically name tax violations alongside Medicare fraud and PPP loan fraud. This is a significant expansion. It means that forgotten cash income, misunderstood deductions, or even old calculation mistakes could now become the basis for a denaturalization case. Here's the danger. If the mistake occurred before you became a citizen and you failed to mention it on your N-400 naturalization form, prosecutors could argue you lied, even if it was unintentional. The key question on your citizenship application. Part 9, Question 15A of the N-400 asks, have you ever committed, agreed to commit, asked someone else to commit, helped commit, or tried to commit a crime or offense for which you were not arrested? If you underreported income before becoming a citizen and were never arrested, but answered no, the government can use that as the basis for denaturalization. It's that straightforward. How DHS and IRS data could combine. The Department of Homeland Security is actively seeking IRS data. In a recent move, DHS requested 40,000 taxpayer records to match with addresses and immigration files. The IRS could only match under 3%, but the push for deeper access continues. Shortly afterward, the Trump-appointed IRS commissioner was out, later named ambassador to Iceland. Reports suggest one factor was his refusal to give DHS more access to confidential taxpayer information. While IRS privacy laws are strict, DHS has a clear interest in breaking through those walls. If they succeed, linking your immigration history with your tax records could be just a few clicks away. How far back can they go? IRS record retention rules vary. 3 years for basic returns. 5 years for some situations. 10 years for more complex cases. No limit when fraud is involved. For fraud-related cases, there's essentially no time limit, making decades-old tax mistakes potentially fair game. The 25 million citizens at risk. About 25 million naturalized citizens live in the U.S. today. The government can't go after all of them, but they don't need to. Even targeting a fraction can create a massive deterrent effect. Likely focus areas will include more recent tax records, which are easier to verify. Employment histories from green card applications that don't match tax filings. If you listed 5 years of employment, but IRS records show no reported income during that period, you could be flagged for review. Real-life risk scenarios. These examples aren't hypothetical. They're the exact kinds of situations that can now be used against naturalized citizens. Working cash jobs before naturalizing and never reporting the income. Forgetting to file a 1099 for a small freelance project. Misunderstanding the rules for certain deductions. Under the old approach, these might have been overlooked, Under the new priorities, there are potential evidence. Why this is different from post-citizenship mistakes. If you made a tax error after becoming a citizen, that alone won't cause denaturalization. The danger lies entirely in pre-citizenship conduct. Prosecutors use that past conduct to argue you were never lawfully eligible for citizenship in the first place. That's why N 400 Question 15A is so critical. It's the legal bridge connecting past financial mistakes to present citizenship status. The harsh reality of civil denaturalization. Civil denaturalization isn't a criminal trial. There's no jury, no statute of limitations, and very few defenses available. Once citizenship is revoked, the individual can be placed in removal proceedings, leading to possible deportation. Why the government is motivated. The IRS estimates tax underreporting costs the U.S. about $500 billion every year. By linking tax enforcement with immigration policy, the government can hit two priorities at once: increasing revenue collection and expanding immigration control. With naturalized citizens making up 7% of the U.S. population, the pool of potential cases is enormous. What you can do now. If you're a naturalized citizen or planning to apply, here are proactive steps you can take. Review and correct old tax filings. File amendments if you spot errors. Answer immigration forms truthfully, especially about pre-citizenship conduct. Seek legal advice from both tax and immigration experts. Even small mistakes fixed now can remove ammunition from future government action. Looking ahead. While it's unlikely the government will attempt mass denaturalizations, this policy shift means the risk is real for targeted individuals. Expect greater cooperation between DHS and IRS, more data sharing requests, and an increase in civil cases built on financial misconduct claims. For naturalized citizens, the safest approach is total transparency in both tax compliance and immigration paperwork. The bottom line: denaturalization is no longer a rare, symbolic act reserved for extreme cases. It's a stated priority, and tax history is now firmly on the table as a reason to strip citizenship. The DOJ memo, DHS's push for IRS data, and the lack of time limits in civil cases make it critical for all naturalized citizens to review their past. The government isn't looking at what you did after you became a citizen. They're looking at what happened before. Protect yourself, stay informed, and make sure your past doesn't undo your future. If you found this update helpful, share it with others who need to know. And remember, if you like this video, don't forget to hit like, subscribe, and turn on the bell icon for future updates. Thanks for watching. See you in the next video.